Hello everyone, my name is Disha Mehta, a legal intern at LEXIS and Company and a law student at Gujarat University. And today we are going to talk about the types of laws in India. So how many types of laws are there in India and how they are divided? So let us know. So the Constitution of India confers various rights to every person. Along with the benefits of such right comes the threat of getting infringed. As the maxim says, ubi jus ibi remedium, which means there is no right without a remedy, throws light on various laws introduced by the legislature with a view to enforce and protect such rights in order to civilize the society and maintain peace and harmony among the individuals. It can also be understood as a rule of conduct which uniform and is applicable equally to all the people of the state. Law is definite and a formulated will of the state. The state makes and implements the rule which is termed as law. As defined by Austin, law is the command of the sovereign. Each law is binding and authoritative rule or value or decision. Every violation of it is punished by the state. The Indian Constitution is the written constitution and is the longest. It contains 450 articles, 12 schedules and 101 amendments. This is the way Indian law system is known to be very extensive one. There were about 1248 laws as of the latest survey in 2017. Now, the laws in India are fairly complex because it maintains a hybrid legal system with a mixture of civil, common law and customary or religious laws within the legal framework inherited from the colonial era, and various legislations formally introduced by the British are still in effect in modified forms today. There is a separate law to govern the Hindus, Muslims, Christians and followers of the other religions. Thus, it can be concluded that the sources of Indian law can be traced back to customs, religious thoughts and morality, legislation or delegated legislation, judicial decision, scientific commentaries and also equity. So, mainly the Indian laws are divided into common law, criminal law, civil law and statutory law. So in this part of the video, we are going to learn about the common law and the criminal law, and the rest of the part, which are the civil law and statutory law, will be discussed in the second part of the video. So let us start. What do you mean by the term common law? So the common law can be traced back to have its origin in England. It came to India along with the infiltration of the British East India Company. The universal consent and practice of the people from time immemorial formed the basis of the common law. Common law is also known as the judicial precedent or the case law. It conveys from the name only that the source of laws are made by the decision of the cases. This was mostly seen in UK, where if a case was brought up in the court of law and if the decision was given by the judge, then that decision was taken as a precedent for the future cases. Thus, while in statutory law, laws are made by keeping in mind the future cases which may arise. The statutes governing civil and criminal justice like the Indian Penal Code 1860, Indian Evidence Act 1872, the Code of Criminal Procedure 1973, the Code of Civil Procedure 1908 and principles of law complied in these codes we have today were primarily derived from the common law principles. One thing that can be said about this legislation is that they have stood the test of time with minimum amendments. Codification of law made the law uniform throughout the country and cherished a kind of legal unity in fundamental laws. The codes apply uniformly throughout the nation. So this is the topic of common law. Now moving on to the criminal law. So the Indian criminal law is basically dealt by the Indian Penal Code 1860, Code of Criminal Procedure 1973 and the Indian Evidence Act 1872. Based on the British criminal law, the Indian Penal Code defines basic crimes and punishment and is applicable to resident foreigners and citizens alike and recognizes offences committed by Indian nationals in abroad. This kind of law is an offense which is considered to be an offense against the society at large, that is, against everybody and not against a particular individual. The police of the state have an important role to play in this kind of law. Murder, assault, robbery, rape are some kind of offenses that can be included in the criminal law. These offenses are classified in criminal law because such wrongdoing threatens all the people around as they could have also been a victim of the same. Criminal law is dealt with by the public services and not by the private lawyers or investigators. So this is the topic of criminal law. If you have any doubt regarding the same or regarding any previous videos, please write down in the comment section below and we would be happy to help. And tell us how do you like it. Thank you.